Welcome to Daily Immigration News. In today's video we will talk about EAGLE Act 2021 summary and its chances of implementing. If you are interested in this topic, please stick around till the end of this video, and for latest immigration related news and updates, please like this video and subscribe to the channel, and don't forget to hit the bell icon to receive regular notifications about the new videos. Let's get into the video. Many professionals working in the U.S. on a non-immigrant visa like H-1B, L-1 aspire to get a green card, GC, which makes them permanent residents in the U.S. Getting a green card opens up opportunities, as these professionals are not bound by visa restrictions to pursue their dreams like starting a company or switch companies. As per the Immigration and Nationality Act, INA, which has guidance on the green cards allocation, of the total 140,000 employment-based green cards available per year, there is a limit of 7%, 9,800, per country. This per country cap is fixed, irrespective of the size of the country. A country like Iceland with a 338,000 population gets the same number compared to India, which has about 1.339 billion population. Many attempts have been made in the past to remove this per country cap. Background of EAGLE Act on per country caps removal: HR 3648. Over the years, there were many bills that were introduced in U.S. Congress to remove the per country caps for employment-based green cards. None of them passed both House and Senate. The most recent Congress bills from 2019 and 2020 that address the same issue are HR 1044 and S 386. You can check the history of news with the timeline for HR 1044, S 386. After a lot of debate, compromises, amendments, the final version of the bill that combined both S 386 and HR 1044 passed in the Senate in early December 2020. Check the final HR 1044 plus S 386 bill that passed in Senate for complete info on it. But, due to disagreements with the final amendments added related to Chinese military and Communist Party associated clauses, the bill was not taken up in House in the final session. Now, the introduced bill today in House, HR 3648, called Equal Access to Green Cards for Legal Employment, EAGLE, Act of 2021, is based on final versions of the HR 1044 and S 386 that aim to remove per country caps. The reason for this new bill introduction is also due to the fact that the other bill, U.S. Citizenship Act of 2021, which promises to remove per country caps for green cards, has not moved since it was introduced in February 2021. Now that you understand the background, let's look at the summary of the bill and all the clauses in it. We have divided the bill summary by topic for easy review. The main purpose of the bill is to eliminate the per country based limits for employment-based green cards GC allocation based on country of birth. The current limits are set to 7% or 9,800 per country for the same. As per the current EAGLE Act of 2021, it eliminates these per country limits. The current bill also increases the limit of family-sponsored green card petitions from 7% to 15% per fiscal year. The limit would be 2% for dependent areas. These are not independent countries, but dependent colonies, parts of certain countries like French Polynesia of France. Effective date of the bill. This would be effective from the first day of the second fiscal year after the bill is passed and signed into law. In general, DHS's fiscal year starts on October 1st. If the bill is passed before October 1, 2021, then it would be effective from October 1, 2022. Transition rules: 9 years. There is a 9-year transition period after the effective date, to better transition and not have major two countries, like India, China, take up everything. 9-year transition period rules for ROW, India and China. Per country levels during the 9-year transition period. Reserved visas. During the 9-year transition period, no country from the rest of the world can take up 25% of the total reserved green cards numbers/visas. These reserved are the 30%, 25%, etc. as in the above table. Unreserved visas. During the 9-year transition period, no country can take more than 85% of the unreserved visas numbers. These unreserved visas are nothing but 70% in year 1, 75% in year 2, etc. Essentially, they are telling that the maximum a country like India or China can take is 85% of this unreserved pool. Unused visas clause. During the 9-year transition period, if any of the visas are left over or unused due to the clauses as listed above, like per country levels and reservations, then such visas should be given to the remaining ones in line without applying such restrictions. Reserved visa for rest of the world with approved I-140. For the first 9 years from the effective date of the bill, 5.75% of the employment-based green cards would be given to the rest of the world, not major countries like India, China, who have an approved immigrant petition, I-140, but waiting in line due to backlog, in the following order. Family members joining primary green card applicant as dependents. Green card applicants, who have not lived or worked in the U.S. at any point in the previous 4 years since they filed their green card petition from outside of the U.S. Any other immigrants from the rest of the world countries, who are waiting in line with approved I-140 for their green card slot. Reserved for shortage occupations, schedule of workers, 4,400. For each of the 7 fiscal years from the effective date, October 2022 to September 2029, not fewer than 4,400 immigrant visas should be made available for schedule of workers as they are described in Section 656.5a. The big catch is that these 4,400 visa numbers should not be taken from the reserved pool set aside for the rest of the world for the first 9 years, including the 5.75% set aside for the same group waiting with approved I-140s. Also, the dependents joining schedule of workers would be entitled to get an unreserved visa not from the reserved 4,400, and considered in the same order. For example, if let's say each of the nurses under these 4,400 reserved visas gets 2 dependents, they will consume 8,800 from the general pool. The general pool is essentially the quota of large countries like India, China. Chinese Student Protection Act. The bill also eliminates the limiting clause in the Chinese Student Protection Act of 1992 and restores 1,000 visas for them. H-1B Program, LCA process changes in Eagle Act 2021. All the H-1B visa-related amendments from the previous bill are added as they were before that are related to H-1B Program and H-1B Labor Condition Application, LCA. Below is the complete list. Post H-1B jobs on Department of Labor. Within 180 days from the effective date of the bill, the Department of Labor DOL should set up a searchable internet website to post the H-1B positions that are available to be viewed by public for free. The job has to be posted for at least 30 days on the website and has to have all the below information. Job description, title, occupational classification, education, training and experience required. Salary and wage details, employment benefits. Location of the employment. Process to apply for the position. DOL may work with private companies, non-profit orgs to develop and manage the H-1B jobs website. Next steps for Eagle Act 2021 or H.R. 3648 bill? The next step for the bill is to follow the typical process for a bill to become law. Usually, it goes through House subcommittees, committees, voting. Many of these could be skipped as well as this bill is not new and can go for voting as well. We need to see how it progresses. As of now, the bill status is not updated on the congress.gov website yet. What are the chances for Eagle Act 2021 to become law? We have seen the H.R. 1044, S386 go through the hoops and could not cross the finish line. If you look at the current text of the bill from Eagle Act 2021, it is not much different from the previous bill that was passed in Senate in December 2020. The key differences are the removal of the clauses related to association of Chinese military or Communist Party and the limits on the H-1B, H-4 holders applying for green cards during the 9-year transition period. Immigration is a priority topic for the current administration, which is a positive sign for the future of the bill. Having said that, we need to see how the dynamics would play in Senate. So, we do not know at this point who can put a hold on the bill. Also, the H-1B program-related clauses are also tricky as they will limit the functioning of outsourcing companies. It is too early to say. This bill has a long way to go. Hope the information provided in this video was useful to you, and we will be releasing a video when we have more additional information on this topic, so please hit the like button and subscribe to the channel to watch more videos like this. See you soon in another video.